So good afternoon, everybody. My name is Patty Schramm. I'm the Parent Resource Trainer Coordinator here for the SALT Talks Lunch and Learn today. Um, this month, this entire month, we're looking at what happens, how do we prepare and plan for when we're gone? And we've been looking at guardianship. We spoke about guardianship last Tuesday, and today we're going to look at guardianship. Um, the roles, and we're looking at the supported decision making, just all that encompasses guardianship, the items that we face and some of the challenges that we face as parents. And so we can plan for the future, for the current, and for the future. And just an FYI, I know during the discussion things might come up, but we are going to be talking about the stable account next week during our SALT Talks evening session. And the following week, we'll be talking about the special needs trust. Again, this in the Tuesday night in the evening session. So with that, I'm going to turn it over. We have Josh Young and Courtney Hineman here, and I'm going to turn it over to them and let them introduce themselves and to go ahead and start the presentation. One question, Josh, is with questions. Do you want them to type it in the chat as they go, or do you want to just hold all questions to the end?
Because we don't know what pace we're going to end up going at, if you want to notify us when we have questions in the chat that are relevant to what we're currently talking about, we can stop and try to answer those.
Okay, sounds good. Thank you.
If you guys just want to document your question in the chat so you don't forget it and we try to answer it later, that's fine too. But anything that's relevant to what's currently on the screen, we'll be glad to stop and try to address. All right. Well, first of all, just thank you for taking the time to talk with us today. Courtney and I have been working together for a number of years now on a topic that we think is really, really important. So we always love to have an audience who is interested in it. So I'm Josh Young. I'm the Director of Operations for ONI, the Ohio Network for Innovation. We do a lot of different things, but what we're probably most known for is our supported decision-making project that we've done for about 4 years now, just kind of helping people understand what supported decision-making is and how to actually practice it in real life. Courtney?
Hi everyone, my name is Courtney Hineman. I'm the community outreach advocate for the board, and like Josh was saying, so we're going to be talking about supported decision making and also about the roles of the guardian. And also the screen is blurry, like it's not showing the presentation.
Yeah, thank you, Courtney. I was going to say that too.
Let's pause. Oh, let's try this.
There. Okay. Yep, we see it now.
All right, let me get this back here. Unlock it. Every time I try to do the presenter view, it pauses it. So let's just do it from memory. Courtney, I know you have your notes, so I'll just do the rest of mine from memory. So you'll just have to help me remember who's jumping in to do what. So I think we're starting with just talking about the fact that Courtney and I are both autistic people. So that looks different for each of us. You know, we each have strengths in different areas. We have things that we're really, really good at. So for example, for me, I'm great at being creative. I'm really good at responding to crisis situations. Those are some of my strengths.
And some of my strengths are public speaking, and I'm also creative.
And then we both have things in life where we need a little bit more support. Like we're not necessarily great at them. It doesn't mean that we can't do it, just that we need a little bit of support to do that. So, for example, I am not great with finances, with money. I could also get some help with organization, organizing things around the house, organizing my work, that sort of stuff. Courtney?
And then some of the things I need help with are planning, and I also need help with communication. Like sometimes when I'll start a story, I'll kind of start in the middle of a story sometimes, and I won't paint a picture from beginning to end. So that's something I need support with, as well as being able to tell everybody the information. That way they can know what I need help with.
Courtney, you're just going to have to stop me if I talk over you because I can't see who's supposed to go next. But
That's me. Sorry.
okay, go ahead.
Now just because we need support in these areas does not mean we can't do those things. We can, we just need a little help. And that's really true of everyone. So it's not so much that one person is more or less autistic than the other. It's really looking at specific situations and understanding that each person has unique strengths and needs. And now you go.
On guardianship. All right. So we're going to talk a little bit about the different kinds of guardianship because there are several. So first, you've got guardian of person. So guardian of person is when someone is appointed to make decisions for somebody else about their living arrangements, their medical treatment, where they work, things like that. It's more of that day-to-day stuff. Guardian of estate is when someone is appointed to make decisions about someone else's finances, their assets. So this can include their bank accounts, any property they have, things like that. So those are technically two different kinds of guardianship with two different functions. Just because you have guardian of person does not mean that you have the legal authority to make decisions about that person's estate, their money, their finances, their assets. And just because you're guardian of estate does not mean you have the legal authority to make decisions about where they live or their medical treatment. So they're very distinct. And an emergency guardianship is a kind of guardianship that can be applied when something has to happen right now, or the person's going to be in the way of significant harm. They're going to get hurt. Something bad's really going to happen in the next 72 hours. So when you apply for emergency guardianship, you're saying, I'm going to step in, make whatever decisions need made in this first 72 hours. After that, the court can extend the emergency period for an additional 30 days. So altogether, it would be 33 days that you can be emergency guardian. At the end of that 33 days, in almost all cases, the emergency guardianship is going to end, and then the person no longer has a guardian. So if during that period you feel like this is going to be an ongoing thing, in most cases, the court's going to want you to submit a second application for ongoing guardianship.
And then for limited, when most of us think of guardianship, we probably think of full guardianship or guardianship being appointed to make all decisions for another people. But remember our example from the beginning? What if someone doesn't need help in all decisions of their life? What if they only need help in very specific areas of life, like medical decisions, for example? Limited guardianship happens when a court gives someone else authority that is limited to make decisions for someone else. So it can be on specific situations like medical decisions or where a person lives, or it might be limited to a specific period of time. Under guardianship, the person retains some of their rights to make decisions, their own decisions.
So last, and this isn't so much a kind of guardianship, but it can be part of the process. It's restoration. So what we need to know and remember about guardianship is that it is the removal of a person's civil rights and any appointment of someone else to make decisions on their behalf. Now we're going to get into some of the nuances of guardianship and address some of the misconceptions, but we have to understand that it is the removal of a person's civil rights. With that said, sometimes guardianship is the right and best way to support someone, right? But there are also occasions where a person can develop capacity to make decisions. or the circumstances that make guardianship necessary change. And so maybe that person doesn't need a guardian or doesn't need a full guardian anymore. In those cases, we can approach the court and petition for that guardianship to be limited or to be terminated altogether.
We're going to look at the process of applying for guardianship, but we can't stress enough that we should always start by asking what we're trying to accomplish with guardianship. Remember, it's the removal of a person's civil rights, so it needs to be taken very seriously and should only be used as a last resort. We'll talk more about this later on, but guardianship isn't intended for people who make bad decisions or decisions we don't agree with. It's really intended for people who, even with support, are unable to understand their options, think about the pros and cons and potential outcomes, and make a decision based on that. The truth is that a lot of people are probably more capable of making their own decisions than they're given credit for, especially if they get the right support to make those decisions.
Okay, so the first step in applying for guardianship is exactly what Courtney described. Stop and ask yourself, what is it that you're trying to accomplish by getting guardianship? Because in some cases, we're going to find that guardianship isn't actually going to do those things. It's not actually going to address those concerns. And there's rule and law around guardianship that says we should be looking for the least restrictive way to support someone. So that's the very first step. After that, if you're going to submit an application for guardianship, you're probably going to need to include this form called an expert evaluation. It's a form that a doctor or licensed clinical psychologist completes for the first time. It asks the doctor, how long has this person been a patient? What are their conditions, their diagnoses? It asks about any impairments that they might have and whether or not the doctor feels that they can take care of themselves and their finances. Ultimately, at the end of that expert evaluation form, the doctor has to check a box saying whether or not they think guardianship should be established. What we've heard, and you'll hear about this a little bit more later, from a lot of medical professionals is that they find this form confusing, but it carries a lot of weight when it gets to the court. So the next step in the process is to fill out and submit the actual application to the court. And every county has different forms, different packets. But usually your probate court's going to be able to direct you to those. Some of them just use the statewide forms. It's going to ask you some generic questions about the person, about the relationship with the person, about why you think they need a guardian, things like that. Once you have the application and expert evaluation, you can submit those to the court. When the court receives those things, one of the first things they're going to do is send someone out to do an investigation. So that's like the court investigator. So the court investigator is going to go out and do a couple of things. They're going to meet with the person. They're going to let them know that someone else has applied to be their legal guardian. And they're going to kind of assess the situation so that they can fill out a report and bring it back to the judge. And they can say a number of things on that report. They can say, yep, met with the person, guardianship is clearly the best thing to do for them. Or met with a person and they don't want a guardian. They're really passionate about that. And actually, there might be less restrictive ways to support them. Or they can come back and say, you know what, there are a lot of family dynamics going on here. Judge, you may need to consider that. If the judge gets the report from the investigator that's kind of in support of guardianship, they're going to move forward with it. Sometimes, even if that report comes back and it's not entirely clear whether the person needs a guardian, they're going to move forward with a hearing so they can take testimony. That's what happens at the hearing. The person who is applying to be guardian goes to the hearing. The person you're applying to be guardian for has the right to attend that hearing. Remember, this is the removal of somebody's legal and civil rights, so they have every right to be there. They even have the right to legal counsel, should they request. But most of the time what happens at a guardianship hearing is you show up, the judge swears you in, takes a little bit of testimony, just kind of confirms the things in the expert evaluation and in the application. And then they're going to make a ruling or a judgment, finally. And that judgment is going to say, yep, person needs a guardian, here's who's going to act as guardian moving forward. When they make that initial judgment, they can also choose to limit that guardianship if they see fit. One of the things that a lot of people don't understand, which is really important to understand about guardianship, is that the judge, the court, is the superior guardian. So guardians like me or like you, we're serving at the discretion of the court. So ultimately, the court can overrule any decision that we make if they don't think it's in the person's best interest. The court also has the authority to change guardians if they don't think that the guardian is meeting expectations, or cite guardians if they're not turning their paperwork in on time. So I'm not saying these things happen often, but we need to understand the dynamics here, that the judge, the court, actually is the superior guardian. If you're going to apply to be a guardian, they do have training, education online, and occasionally in person that's available. We would really recommend that whether or not you're sure about applying for guardianship, that you at least enroll and take that 6-hour fundamentals course. In rule, it says that guardians are supposed to take this anyway, but local probate judges can waive that expectation or that requirement, especially for family members. And we see this happen a lot. But we still encourage you, if you just want to learn more about guardianship or get some more context to understand if it's the right thing to do, that 6-hour fundamental course is really helpful.
Once you're a guardian, you're also typically required to do ongoing training every year. There are a bunch of 3-hour trainings available on the same website. Topics like housing decisions, ethics, medical decisions, and older age and end of life decisions.
All right, so let's look at some definitions or terms that are related to guardianship that you'll hear, that are in rule. So this is coming from the Ohio State Supreme Court, just so you know. So this is the guidance from the Ohio State Supreme Court to guardians and to local courts. Courtney, did you have this one?
Yes, I did.
Go ahead.
So the court says that a person who is incompetent still has the capacity to make non-life-threatening decisions, like what to eat or what to wear. So even when a person has a guardian, the court says they still probably have the ability to make some decisions in their life. And it's not just limited to what to eat or what to wear, because remember, everyone's ability is going to be different, and a person's capacity to make decisions might often depend on whether or not they get the right support to make those decisions. For many of us, if we don't get the right support, we don't necessarily have the capacity to make decisions by ourselves. Think about your finances. Have you made all the decisions about your finances, big and small, without support from anyone else? Or did someone help you understand your options, explain things in a way you could understand? The same can be true for medical decisions. Sometimes we need things broken down so we can understand better and make an informed choice. 2, a person under guardianship has the right to participate in decisions that affect their lives and have their needs, desires, and preferences considered. This one's really important. Having a guardian doesn't mean the person is suddenly cut off from important decisions about their life. The court says they have the right to be involved in those decisions. So that's a really important responsibility of the guardian. Taking the time to know the person and understand what they want and need so it can be factored into the decision-making process.
Hey, Courtney, when we get to new slides, can you just say, this is me or this is you? It'll help us go faster.
Yeah, this one's you.
Okay. So the ultimate responsibility of the guardian, according to the Ohio State Supreme Court, is to assist the person under guardianship or the ward with decision making. Sometimes we think of guardianship as having ultimate authority and that we have to step in and make decisions for the person all the time. And that's not really what the court says. Assist the person with decision making in those creative ways that work for them. We still have the responsibility and the authority to step in and make decisions when we need to, but there's a lot of assisting and advocating that goes on or is supposed to go on within guardianship.
This one's me. The court also says that guardians should remember to make decisions based on what the person under guardianship would want, not necessarily what the guardian wants for that person. Your job is to know and understand that person well enough that you can make their decision. In most cases, you would think they would make for themselves if they were able to. And that one's you, Josh.
So best interest, you're going to hear this a lot as it relates to guardianship. Making decisions in the person's best interest. So the best that the court does at defining what best interest is what's the decision that a reasonable person would make in the same circumstances, right? Now, I will tell you that I have definitely been called unreasonable in my life at some points. That doesn't necessarily mean that I didn't have capacity to make the decision. So there's something about this that is subjective a little bit, right? But that's the best attempt at kind of describing what best interest means.
This one is often surprising to many people. The court says whenever possible, the guardian should defer to the preference of the person who is under guardianship, as long as it's not going to result in immediate and significant harm. So, for example, if the person wants to move to a different home because they're not getting along with their roommates, or they want to move closer to their friends, unless there's some reason that would cause significant harm, that's the decision the guardian should support and express. It also means that the guardian should support that decision, even if it's not necessarily what the guardian would choose. If you live a couple houses down from the person you're guarding for, well, that's convenient for you to check in and visit them, right? But if they move to the other side of town and now it takes you 30 minutes to see them, that doesn't really qualify as significant harm. So even though it might be more convenient for you as a guardian, you still need to support their decision to move. Of course, there are all kinds of details to consider with each decision, but this is the general rule. And then if the person really has not ever had the ability to express their preferences or make decisions for themselves, the guardian should explore what other important people in their lives have to say. And all guardians must act in the best interest of the ward and make decisions, and those decisions should support the ward's wishes whenever feasible, but not harm the ward. This one's also me. So hopefully you're getting a sense of the role of the guardian. It's very unique and has some specific rules to follow. This can be challenging when the guardian is also a family member because those are two distinct roles. As a guardian, you're supposed to consider all the things we just talked about. As a family member or parent, well, you're going to have strong opinions about what you think is best, even if that doesn't align with the guidance from the court. So there can be some role conflict here. And it's hard, maybe even impossible, to keep switching back and forth between them. But that's what's being asked of you as guardian. This one's you, Josh.
All right, so the court is also going to consider potential conflict of interest when appointing a guardian, and specifically when they're looking at family members as guardians. And why? Well, they don't want something else to influence the guardian's decision making. So what are some examples here? They give two main ones. The first one is family members who are also paid providers of direct services to that person. So how does this play out? Hypothetically, if I'm providing services to my brother and I'm getting paid to provide those services, and then a judge appoints me as guardian, I'm likely to decide that it is always in my brother's best interest for me to be the provider, but I also financially benefit. So that could create some potential conflict of interest. Courts are aware of that. So they're going to consider those things and probably ask some more questions about those arrangements if they exist. The other example they give is when, for example, my brother lives with me and I am his payee. So I get his Social Security money and I manage that, right? Or maybe I'm also guardian of estate for my brother and he lives with me. So if I'm living with my brother and I have to use some of his Social Security benefit to pay the mortgage and the utilities, well, just like the example that Courtney shared, if my brother decides that he wants to go live on his own, as long as that's not going to create significant harm for him, then really that's the decision I'm supposed to support. But what does that mean for me? That might mean I no longer have the funds to pay my own mortgage and utilities. So that could definitely influence my decision making. Again, the court just wants to recognize these, talk through them, make sure that it's not going to be a conflict of interest. So
This
we just
one's
want,
yeah.
go ahead.
Oh no,
We just
I
want
was
to
gonna say
reiterate
this one's also
that before you apply for guardianship, just ask yourself, what are we trying to do with it? What are our concerns? Let's dig into those, because you might find that there are some less restrictive alternatives to guardianship that don't remove the person's rights, that can do those things that you want to do, that can address those concerns. So always ask that before you apply. And in fact, while you're guardian, you can continue to ask this question and make sure that guardianship is still the right way to continue supporting the person with decision making. So we're going to take a look at sort of the process of applying for guardianship through the lens of the different organizations or systems that you might interact with during that application process. So let's start with school. There are a lot of misconceptions that are kind of born from schools, not intentionally, just because schools don't necessarily have the information they need to pass on to parents. So many parents will hear, oh, I've got to get guardianship for my son or daughter when they turn 18. That's just not true. There's nothing that says that that has to happen. Now, that might end up being the best thing to do for some people. But if you don't know that you have other options, then it's hard to make an informed choice about whether or not guardianship is the right thing. In fact, if we can build decision-making skills and self-determination in people while they're younger, then they're likely to have more capacity as they get older. And as we're trying less restrictive alternatives to guardianship, over time we might find that we've done our very best, we've done our due diligence. These things aren't working the way they need to. We might need a different level of support, like guardianship. You can apply at any point later in life after 18. One of the other misconceptions is, well, if I don't have guardianship, I'm not going to be involved anymore, right? I'm going to get cut out completely. Now, what is true is that at the age of majority, that person is now legally an adult, right? So they now make their own decisions. That doesn't mean that parents or other supporters can't be involved. We can look at all kinds of releases of information that might serve that purpose. Hey, you want to know what's going on at the medical appointments? Is son, daughter, loved one willing to sign a HIPAA release? Great. That might be all that's necessary. Now you can know what's going on. Talk to the doctor. Maybe even understand what the doctor's saying so that you can explain it to your loved one and help them make their own decisions about it. One of the biggest misconceptions that people often have is that guardianship is going to protect the person. So from harm, from abuse, neglect, things like that. There's actually no study that says that that's true. There's no study out there that shows that people under guardianship are safer than people who are not. There are some studies that suggest that sometimes people under guardianship are actually at greater risk for things like exploitation, right? So guardianship doesn't really allow us, in most cases, to force somebody to do something or to prevent them from doing something that they're determined to do, right? So it could be medications, right? The person doesn't want to take their medication, but you as guardian decide that they should. You give consent for them to take that medication. Well, what if they say no? They don't want to take their medications. What then? So it's not always that simple. You or me, Courtney?
Me. The next one we're gonna look at is community, various organizations you might interact with, but especially your county board of BP. So what we'll be talking about is a supported decision-making agreement, which is basically having people who support you sign this document to show that they are helping you make your decisions. And then we will also be talking about charting the life course tool that can break down decision making into where you need help with and where you need support to make decisions. Okay, next slide. So this support is a support decision-making agreement. It's just one version, but it's a tool to document who the person's chosen supporters are and what kind of help they want from them. If we look at this another way, it can be a way to survey a person's community of support. Those connections are one of the foundations of self-determinations. There are other tools out there that can help you identify important relationships, so use whatever works. And if you're having trouble identifying supporters to list on this tool, well, that just might be an area where you can start looking for people, developing relationships for the future.
You want to talk a little bit about each page of this?
Yeah. So the first one basically just says that you want help to make decisions, but you're not giving up your right to do that. And then the second page just says who you're deciding to pick as your supporters. And then the third page says what type of support that they will help you with, like maybe medical decisions or helping you understand pros and cons, things like that. And then the last page is just where everybody signs it. So this is just exploring decision-making supports, and then each box has a different level. Like you can make this decision with no support, or you need a little support, or you need someone to decide it for you. So it just depends on where that person needs help, where they would check, which one they would check.
All right. and we talked about this a little bit already, but at some point in the application process, you're going to interact with medical professionals and the doctor because they have to complete and sign off on that expert evaluation, which carries a lot of weight when it ends up in front of the judge. The judge, he or she, is kind of deferring to that expert, but we want to offer at least something to think about. My doctor, I would trust to tell someone else whether or not I have the capacity to make medical decisions, because that describes my interactions with my doctor, right? I'm not sure that I would trust my doctor to tell someone else whether or not I have capacity to make financial decisions, because that's not the nature of my relationship with my doctor. But that's what doctors are asked to do: fill out this form, kind of weigh in holistically on whether or not the person has impairments that prevent them from being able to make their own decisions. This is kind of what that looks like, the first page at least. There are other tools that we can use in the medical field. So things like a health passport. These are kind of like one-pagers that just allow a person to document their preferences, what they want to happen in terms of their medical treatment. It's a great way to communicate these things to medical professionals, and to just start the conversation about what kinds of decisions I might need to think about so that I can come up with answers if I'm ever asked. What do I want to happen in my life? There are tools out there that help us just have those conversations too. And admittedly, some of these conversations are harder than others. It might be about advanced directives. What do I want to have happen if for some reason I am unconscious, or the decision needs to be made about life support for me? What do I want the end of my life to look like? Sometimes these are things that all of us avoid, but they're really, really important to talk about. And when we can present it in a way that the person can understand, engage in those conversations, often they can express what it is that they want or need. So we're going to watch a quick video here of that in practice, just medical professionals finding creative ways to support and respect other people to make their own decisions.
But the most important thing, when we always ask, as I did here today, Sam, is it okay that we talk about this? Is it okay that the doctor listens to your heart right now, puts a stethoscope on your chest? Those kinds of things, we always get his permission and his acceptance before we proceed. We want always to be understood and always clear that he has right to his space and to who touches him, when and how. And he's not shy about letting us know if he's not okay with something, and we want that. Absolutely.
This next one's also you, Josh.
Great. So finally, during this application process, the last system you're going to interact with before a judgment is made about guardianship is the court. So here's just an example of the first page of an application. So I just want to point one thing out here. The rules about guardianship, they're kind of outdated. So they're still using terms that many of us can take offense to, but it's what's written. So you'll see the word incompetent there. And that's essentially what the judge is doing when they make a ruling that someone needs a guardian. They're judging that person to be incompetent. Well, as we've talked about, there are many, many ways to support people, and someone may have capacity to make some decisions and not others, or depending on the circumstances, they may be able to make some decisions about others. Think about when we're really stressed or pressed for time or just had a really bad day. Our capacity to make decisions can change. This is an example of that court investigators report. So this is another point at which guardianship could be reconsidered. If the court investigator goes out and says, yep, I don't think guardianship's the right thing for this person. Let's look at something less restrictive. And if you are appointed guardian, Courtney alluded to this earlier, but there are reports that you're going to have to submit on an annual basis. One of those is the guardian's report. You also have an annual plan that you'll have to submit to the court. Every time you're going to complete this is an opportunity to review whether or not guardianship still makes sense for the person, or whether or not full guardianship still makes sense for the person. So the rules around guardianship actually say that the guardian's responsibility is to notify the court if less restrictive alternatives are possible, if the person's abilities or capacity has changed or improved, or if guardianship is just not serving the person. And there are some situations where guardianship's really not doing anything for the person. So what the rule says is that the guardian's responsibility is to notify the court in those situations.
So, Senate Bill 213 would recognize SDM as alternatives to guardianship so that people would consider it more often before applying to guardianship. It also mentions an SDM plan, which is like the SDM agreement we were talking about earlier, that can be used in place of guardianship. The bill is still being voted on, but it has a lot of support. So this SDM stuff we're talking about is real and important, and Ohio is starting to do something about it.
All right, so at some point in our presentations, and understandably, we hear this all sounds nice, but not for the person, not for the person I know, I work with, right? And Courtney and I will never pretend to know your life, your loved ones, your situations. We will offer one perspective, though, and this came from an attorney who was talking about guardianship several years ago and really made an impact, so we try to share it where we can. So she said that anyone who can express their desires, what they want, what they don't, right? Whether that's blinking their eyes, using words, pointing, using pictures, gestures, maybe using technology, however they do it, if they can express their desires, then they can make at least some decisions. It's just about presenting those options to them in a way they can understand and respond to.
And while SDM should definitely be used as alternative to guardianship, we can and should use it alongside guardianship. Obviously, as guardians, we know that we have the authority to make decisions for the person, but that doesn't mean we have to exercise that authority unnecessarily or with every decision. This slide is what we want to get away from. It's not an either or. These things are not necessarily mutually exclusive, and they don't have to be at odds with one another. We can do both. Now, that doesn't mean go ahead and get guardianship because, or even if it isn't needed, because we can still use SDM. We should still treat guardianship as a last resort. But if it is in place, maybe for those people who are already under guardianship, it can be supplemented with SDM in a lot of situations. So even when guardianship is in place, there are still many opportunities to use supported decision making, to support the person under guardianship to make their own decisions and practice decision making skills. Some of these opportunities might seem smaller, like choosing what food to eat or what clothes to wear, and others might seem bigger, like where to work, who to trust, decisions about treatment, things like that. With the right kind of support, the person under guardianship can be involved in all of these decisions. Supported decision making really goes hand in hand with the Americans with Disabilities Act. So if somebody was using a wheelchair and they couldn't get into a building, we wouldn't go up to them and be like, oh, well, I guess you can't get into the building. We would be advocating for them and making sure there was a ramp so that they could be able to get into the building. And it's the same way with supported decision making. Just because people need help to make decisions doesn't mean that they're not capable of making their own decisions. They just might need a little help with that.
All right, we're going to talk to end here a little bit about the rights that a person under guardianship actually retains. So yes, many of their legal and civil rights are removed when a guardian is appointed, but the court's also very clear that they retain some rights. Courtney, is this you?
Yeah. So I know we talked about this earlier, but it's good to repeat it. A person who is incompetent generally still has the capacity to make non-threatening, life-threatening decisions like what to eat or what to wear. A person under guardianship has the right to participate in decisions that affect their lives and to have their needs, desires, and preferences considered. Voting, guardianship does not terminate a person's right to vote. Guardians cannot complete ballots on the person's behalf. That one's you, Josh.
So guardianship doesn't prevent somebody from driving or getting their license either. It doesn't require our permission as guardian to do that. If there's an issue, it's really the responsibility of the DMV and a physician to make that determination.
Guardianship does not necessarily prevent a person from marrying. If they may do so if they have the capacity to enter into a marriage contract, that is, understand the meaning, rights, and obligations of marriage. And guardianship terminates a marriage. Let me try it again. Marriage terminates guardianship.
Yep, you got it. So one little nuance to that is if someone has a guardian and they get married, yes, guardianship is terminated in most cases. The assumption is kind of that the person has the capacity to enter into that marriage contract and they now have a partner formally that can help them with those decisions. If there are strong feelings that this person, even though they are married, still needs a guardian, typically that's going to require someone to reapply to be guardian for them. All right, guardianship also does not terminate that person's right to sexuality or to engage in sexual activity. So what the court says about this is that if there's some conflict over whether or not the person really understands the options, understands the pros, the cons, potential outcomes, that it can be important, helpful to get an assessment done of that person's knowledge. Are they going to enter into this voluntarily? We also don't have the authority to make decisions on their reproductive rights. So childbearing, abortion, sterilization. These are not things that we as guardians have sole authority over. The court says is that if there is some kind of conflict, we can always go to the court to weigh it. Because keep in mind, the court is the superior guardian in cases.
Sometimes with DODD, Department of Health, and CMS, regulations conflict with directives from guardians. When unsure what to follow, all parties should work together to reach a resolution in the best interest of the person. The court can facilitate if necessary.
So especially if you're working with a county board, these are called rights restrictions. They used to be called behavior support plans, and maybe some places still do refer to them as that. But it's things like, well, I think this person's access to, I don't know, a smartphone needs to be restricted for their own safety, their own good. But the county board has their own rules that they have to follow. They may not be able to write that into a plan. They may not be able to sort of mandate that a service provider enforce that. So there can be some conflict. We've got different rules, different expectations, different systems. And those two parties haven't really figured that out yet, but they acknowledge that there are some potential problems. All right. So finally, let's just talk about health, safety, and happiness, because these are issues that often come along with guardianship. So this is a simple tool that can help us think about risk, if that's one of the things that's prompting us to think about guardianship, or if we're already guardian and we're trying to make a decision that involves risk. This risk matrix just kind of lays things out. On the left-hand side, how likely is this bad thing that we're thinking about to happen? Across the top, if it does happen, how bad is it going to be? So, for example, if I decide that I want to go out to eat this Friday at a special restaurant, but I don't make reservations, am I taking a risk? Yep, a risk that they won't have any seating available when I get there. But what kind of risk is that? That's pretty low risk, right? Now, if I speed, I go over the speed limit. Depending on how fast, that risk might increase or decrease, right? But is that risk, if I'm going 5 miles over the speed limit, high or extreme? In most cases, no. And then there might be things like joining a recreational sports team or trying something new that we haven't done before. Sometimes we might determine that there is moderate, even high risk in those things, but it's a risk we're willing to take or accept. Because when you kind of take a step back and look at this chart, ask yourself, where does growth happen? Because there is no place on this chart that says no risk. Every decision has risk, right? Your decision to drive somewhere today has risk. We just kind of take it for granted. But what I haven't heard yet is anyone tell me that once they left home and went to work, or they drove back home from work, from the store, that they got out of their car and said, man, I really grew a lot from that drive home. Because we don't tend to grow from those low risk situations. We tend to grow more from moderate and potentially even high risk situations, as long as we're kind of careful about which risks we take. So not reckless, but thoughtful about it. So if we prevent people or deprive people from having any sort of risk in their lives, we're also depriving them of opportunities for growth. Because life is calculated risk. Every decision we make is a calculated risk.
This one's me. So when we consider the risk, are we thinking about our own personal beliefs and experiences, and our experience influencing what we define as unsafe? Research shows that the magnitude of risk presented by social isolation is very similar in magnitude to that of obesity, smoking, lack of access to care, and physical inactivity. So if we're going to talk about the risks associated with those things, then we need to talk about the other side of the risk as well. Risk is multidimensional. We need to consider it from more than one angle when we talk about it. And maybe it's someone who wants to try something new, go on a date without staff, use Uber for the first time, something like that. Is there risk in doing those things? Sure. Never mind that many of us have done those things pretty frequently. But is there risk associated with not doing those things? Definitely. A lack of experience, of learning, a lack of opportunity and autonomy, of self-determination. And these risks are very real as well. We know that people with more self-determination, for example, are actually better at resisting abuse and exploitation, and that people with less self-determination may be more at risk, especially in their mental and emotional well-being.
All right, so I think if we're just going to sum things up, there is a continuum of supports available to help people make decisions. The more knowledgeable that we are about the continuum, the more creative we're going to be able to be in applying or offering those supports to people. And yes, at one end of that continuum is legal guardianship. Sometimes that's where we're going to end up because it is the best way to support the person with decision making. But all along the way there, let's look for those less restrictive options that are available, see if some of those work. It allows a person to retain their civil rights and build that self-determination that's so critical to success as adults.
So, with all of that, does anyone have any questions, comments, or even concerns?
I haven't seen anything in the chat box. Now, if anybody has any questions, please feel free to drop it in. So we can get some answers for you if you do have any questions regarding what was discussed.
Do you need to get a lawyer to do guardianship?
Not necessarily. So if you're just an individual person, you might be able to navigate that application process without an attorney. An organization that provides guardianship services, generally they're going to need to have an attorney help them. That's kind of what it says. But as an individual person, you don't necessarily need an attorney. That doesn't mean that it's not helpful to have an attorney navigate the application process. But yes, you can apply for guardianship without an attorney. One of the things to consider there is the fees that come with guardianship, which is not something we talked about earlier. But every court is going to have fees for filing documents with them. And from my experience, those fees can go from like $250 to $600 or $700 just for the initial application process. So then if you're going to consult with an attorney to help with some of that, you're adding attorney fees on top of that. Now, there is a form you can submit to the court, which is like an affidavit of indigency. Basically says that this person that we're applying for guardianship for, they do not have finances to cover these costs. And if the judge reviews that and approves it, then they can waive those costs. And a lot of times judges will do that. But no, you don't have to have an attorney to file an application. It can be helpful.
Thank you. Another question is, how long does the whole process take? Once you turn in your application, will you get a hearing right away, or is there a wait time? Like what is that to expect once you turn in your application?
Two answers to that. The first one is if it's an emergency guardianship, you can expect something pretty quickly because they're going to treat it as emergency. Something needs to happen in the next 72 hours. If it's an indefinite non-emergency guardianship, it's going to be a whole lot like scheduling a doctor's appointment. It's going to depend on that doctor, that office, their availability, what is already on their schedule. So sometimes we'll submit an application and find that we can get in 2 or 3 weeks. Other times we'll submit an application with a different court and find that our hearing is in 2 months. So it really just does depend on the local jurisdiction.
Thank you.
Great questions. Does anybody else have any other questions before we wrap it up? So, I mean, you can still.
I have
Oh,
one
go
more.
ahead.
Sorry, Patty.
Yeah, no, you're fine, Becky. Thank you.
When you go to court for the hearing, is there anybody that needs to go with you besides the person, you're getting guardianship of them? Is there any support system that's supposed to come, or is it just you and the person? Or what does that look like? What do you expect in a hearing for guardianship?
Sure. So every judge has slightly different expectations. So you can always ask the court what their expectations are. The courts will not give you legal advice. They're not allowed to give legal advice. You can ask what the judge's expectations are. But in general, part of that application that you're going to complete includes a next of kin form. So anytime you're applying for guardianship, you have to list all of that person's next of kin, because all of the next of kin have to be notified that someone is applying for guardianship so that they have the opportunity to either approve it, waive like any objection to it, or show up and maybe object or submit their own application for guardianship. So potentially next of kin could show up. Now, if you're choosing people to come to the hearing, I would probably choose people who can offer testimony in support of the guardianship, if that's what you're applying for. Now, the person who is potentially going to be under guardianship may decide that they want someone else to come to testify on their behalf, in which case they can have legal counsel assigned to help them with that. Does that answer your question?
Yes, it does. Thank you.
Yep.
Are there any other questions? If you think of something later, feel free. You'll find the presentation is in our Google Salt Drive. If you can't seem to access that, I'll be glad to send it to you, and you can email me and I'll forward it to you. But for any of the contacts for Josh, Young, or Courtney. But I want to just thank Josh and Courtney for taking the time out of the middle of their day for presenting to us regarding this topic and to supported decision making and the guardianship roles. Great explanation, and I want to, just thank you all for coming. Um, and just one more opening is any other questions before I close?
If,
All
if
right.
we can just thank everybody for their patience too. We typically can see who's supposed to go next with their slides, and for whatever reason, it didn't allow us to see that. So we were operating a little bit blind there. So thanks for your patience with that.
Oh, you did a wonderful job, both of you. So let me go ahead and stop the recording just in case someone doesn't want to speak while the recording is on. But thank you again for presenting and speaking with us today.